Good morning, everyone, and welcome to today's webinar titled Empowering Creators Navigating Performers' Right in the Age of Digital Media and Intellectual Property. The webinar is being organized by the Center for Development of Intellectual Property and Research, which is a premier institution under the Indian Center for Child and Human Rights, and it is India's first non governmental research organization dedicated to intellectual property rights. With a focus on promoting and safeguarding IPRs, the center works to create a supportive environment for creators and innovators across various sectors. On behalf of the center, I'm delighted to have you all with us today. Before we begin, I would like to cover a few basic points. If you have any questions, you can send it across during the webinar or towards the end of the session via the live chat option. A recording of the session will be available on our YouTube channel, so feel free to watch it again or share it with others. Now, it is my privilege to introduce our esteemed guest speaker, Dr. Rohan Thomas, an expert in copyrights and intellectual property law. Sir is a prominent figure in copyright law, international intellectual property law, patent law, tort law, and consumer law. He has participated in numerous national and international conferences and has contributed significantly to academic research in these areas. Sir is currently an assistant professor at NALSAR University of Law, Hyderabad. Previously, he had spent 9 years as an assistant professor at National Law University, Jodhpur, where he served in various leadership roles. Sir has earned his PhD in performers' rights with a focus on the topic, the conundrum of rights pertaining to background performers. As the world of digital media continues to evolve rapidly, performers' rights have come to the forefront of intellectual property discussions. Sir has extensively studied how copyright law and performers' rights intersect in this digital era. Today, he will share his insights into how performers can protect their work in an age where distribution platform and copyright issues are more complex than ever before. We are truly honored to have him with us today. Without further ado, please join me in welcoming Dr. Cherian Thomas. Sir, over to you.
Thank you, Anandita. I hope my voice is clear. There is no lag. Okay, great. Thank you for inviting me to this webinar. I'm deeply grateful to be a part of this endeavor to spread awareness on intellectual property, especially on an area which is very close to me, performance rights, something which is not given a lot of stress usually, even when intellectual property is taught as a wide subject matter. Usually copyright as a broad area is taught, but then performance rights do not get the kind of focus that they deserve. This is an area on which I have, as Anindita pointed out, done some research of my own, wherein I have been able to get some inside perspectives on the manner in which professional performers feel that feel about intellectual property and whether it can in fact give them some kind of a recourse to the problems they seem to be facing within the industry. So thank you again for this invitation. I hope for this to be an engaging discussion. Please feel free to drop in your questions or queries in the chat box as we go ahead with this discussion. I'd be happy to take them up as and when they come up. But then towards the end of this discussion, I intend to keep some time off to open it up for Q&A. So anything, so the title of our discussion today, as you can see, is Empowering Creators, Navigating Performers' Rights in the Age of Digital Media and Intellectual Property. I am aware that for this webinar, there are people who are joining in from the industry. They've been invited as well. This is an open webinar. This is not only restricted to IP honors students, or this is open to law students in general, people who are in academics, generally people who are practicing in IP, also very importantly, people from the industry. So my attempt would be to not make this too technical. Hopefully through the course of illustrations, I'll be able to explain what exactly we are going to be covering and hope to provide some important takeaways to everybody, people who are looking to create, people who are looking to become a professional, and professionals who are already engaged in the industry. So in this title, you'll see that we are looking to address a very small sub area within performance rights, which is that of digital media. So digital media is one arena of um, commercial exploitation by performers of their performances. I call it small because, from the perspective of performers and um, the kind of benefits they seem to be accruing from it, seem small. But as a mode of commercial avenue itself, for the larger parties involved, such as producers of sound recordings or cinematograph this is a whole um, ball game that is inclusive of a lot of revenue, and if shared properly, performers can in fact get a lot of um, remuneration and recognition from it. That's one. One, that we are connecting this to digital media, and second, we are also looking at this from the lens of intellectual property. And this, as I will try and engage today in our discussion, this is important because when we approach this from the perspective of performers, we can approach this from the lens of labor law as well, and we can approach it from the lens of IPR as well. So, where does the benefits of labor end and where do IP begin? And do they essentially operate in a hybrid space? That is also something that is important, and we will take a look at that as well. So, I've split our discussion into 6 segments. In the first segment, I will be contextualizing our discussion with the help of some examples. I will try and explain who exactly is a performer. In the second segment, I'm going to be looking at 2 important questions, and this I hope to achieve with the help of some illustrations, which hopefully we can connect to. At one point of time, you might have attempted to create something and upload it onto YouTube or some other platform, and you probably wondered whether you were a performer. So, are you a performer? And what exactly is it that you're performing? So, that's again something I'll be touching on in the second segment. Segment 3 looks to um, answer what are digital avenues that are available for performance. So we're going to be looking at some avenues such as hosting sites, which no doubt you are all aware of. But just to put it out there, what are these avenues? Segment 4 looks to touch upon originality of performances, because one of the features that we associate deeply with copyright law is the feature of originality. And originality takes up a lot of discussion in copyright classes inevitably. So whether that qualitative threshold is in fact applicable to performances as well. That's segment 3. Segment 4. Segment 5 looks to whether performers actually need empowering. You know, so because this topic looks to empower creators, segment 5 looks to answer this question on whether performers actually need empowering, and whether something like intellectual property can be used as a tool for empowerment. And for this purpose, I will reflect on my research within the industry, wherein I hope to connect some empirical study that I had done and the kind of reflection that I was able to arrive, reflections that I was able to see. And segment 6, which is, if in fact performers need empowering, then how does IP empower performers? So this is the way in which we're going to be looking at this discussion. So Um, the first segment, let's look at contextualizing. So on your screen, you'll be able to see these two images. The first image is of a singer, that's Mohit Chauhan. The other image is a poster of a very popular film called Rockstar. Now, in this film, Rockstar, which is Ranbir Kapoor's character, Rockstar's voice is in fact Mohit Chauhan's voice. So Mohit Chauhan is the singer who is singing for the actor's character. So, so the question is, why not just allow the actor to sing for his character? Why not just allow that? Sure, it's quite evident that the actor has a lot of popularity, and that's the reason why he's been signed to the film. Why isn't it that the producers allow him to just sing? So, one thing seems very clear, that the fact that Mohit Chauhan has been brought in to sing for the character uh, reflects on the fact that Mohit Chauhan is in fact bringing in a lot of value. And this value is something that we see on account of consumer perception. Because at the end of the day, a film like Rockstar is a business endeavor. It's a business endeavor, it's capital intensive. The producer of the film has invested a lot of capital. He's brought in a lot of resources, a lot of people who work together to make the film a success. So it's a commercial endeavor, and no doubt, in order for this endeavor to be as successful as possible, the consumer perception has to hold a lot of value. So, Ranbir Kapoor is not, in terms of his performance, a skilled actor. He's not a skilled singer. So, in this comparison, you can see that the character of uh, the character in the movie Rockstar, which is played by this actor, the actor is a performer. So there are two categories here. The actor is a performer, and the singer Mohit Chauhan is also a performer. Both of these performers coming together to enhance the value for consumers who are perceiving this film. So that portion of the film in which the song is displayed as an audiovisual, that audiovisual segment is enhanced. Its value is enhanced not only by the actor but also by the singer. Now, there are other performers also who must be given recognition, though I have not mentioned them within this slide, but quite clearly the instrumentalists, people who are providing that expression, also are performers. They are also adding value to consumer perception. If I can just share my screen, I'll show you one clip. So this is a clip from this movie called Gulam.
बड़े लगी क्या अरे वो चार्ली यार तेरा लफड़ा क्या उसके साथ
So in this video, I hope you can hear the voice of Rani Mukherjee. Rani Mukherjee is an actor. So I hope you've noticed that voice. I'll play another clip. This is a interview of Rani Mukherjee. So the fact that you've seen these videos, Anandita, can you share my screen? I mean, share the slide. Yeah, thank you. So when you saw these videos, you must have noted the difference in voice. In Ghulam, Rani Mukherjee's voice is a is a shrill note. It's a shrill note. It's slightly on. It's a higher note, and her voice is generally a bass note. It's a lower note, and um, the fact that her voice is so different in both of these is because in Ghulam, that was not Rani Mukherjee's voice at all. That was, if you see in this image, you can see an image of Rani Mukherjee, the actor, and you can also see the other image, and that is Mona Shetty. And Mona Shetty is a voice actor. She does dubbing. She's at present she is now a producer, but she also is a dubbing actor. And in Ghulam, she is the voice of Rani Mukherjee. So the consumer who is looking at that film, who is perceiving that film, and at that point, Rani Mukherjee was starting out in the industry, so there weren't many people who noted, who knew this distinction between Rani Mukherjee's actual voice and um, the voice that was on the screen. So, for anybody who watched that film, for them it was as if Rani Mukherjee was delivering those dialogues. And so, no doubt, Mona Shetty, in providing this dubbing, has brought in a certain type of skill, and the value which that has brought to the film is akin to the kind of value that a singer brings to a film like Rockstar. So these actors are also performers. They are bringing in a certain skill set. That skill set is being used in a specific way so as to help enhance the value of that performance, which Rani Mukherjee is delivering for the consumers. On the screen, you can see this image of a very famous actor. You'd all recognize him as Hrithik Roshan. With Hrithik Roshan is an individual who you probably do not know, and so this the image on the first image is an image taken from this film of Hrithik Roshan's called War, and this second person standing with Hrithik Roshan, that's his stunt double. That's a stunt double. His name is Mansoor Khan. And all those scenes where you saw Hrithik Roshan falling on the ground and taking a beating, um, those scenes were actually Mansoor Khan uh, who was being shot by the director. So here again, we have an individual who's brought in a certain skill set, and he's delivered it with such an impact that the consumer is, the consumer's perception is enhanced. So be it a singer, be it a dubbing artist, be it a stunt actor, they are all bringing in a certain skill set, which, and this is central to our understanding, that they are delivering something of value, which is translating, at least for the producer, it's ringing the bell. It's ringing it's bringing in a lot of money, and that's really the question of how that money is trickling down to performers, and if it is actually trickling down, whether it is reasonably trickling down, and whether there is any recognition that these performers are getting in terms of their performances. So, just to do a quick recap of what we are trying to understand here is that we are placing this in context. We are placing it in context to our understanding of what is value. So, when we look at a film and we consider popular actors like Rani Mukherjee or Hrithik Roshan, we must also consider performers like Mona Shetty and Mansoor Khan. When we are considering actors like Ranbir Kapoor, we also need to be considering the singer Mohit Chauhan, who is singing for that character. So, uh, um, while Mohit Chauhan, you'll see in terms of popularity, in terms of recognition, you can clearly see there is also a segregation. While a person like Hrithik Roshan or Rani Mukherjee are incredibly popular, you recognize them by face, you will recognize them for their contribution. But there are also those performers who you probably don't even know. You're probably seeing for the first time. Like Mansoor Khan is probably a person who you're hearing of for the first time, who you're seeing for the first time. But that's really his skill. Mansoor Khan's skill was that he was able to make the consumer believe that it was in fact Hrithik Roshan who was taking that beating, who was doing those stunts for the film War. Now, now that we understand who these performers are and we can put a name and a face to these performers, let's situate performers within the copyright universe. Where exactly do performers fit in? Now, if you look at this provision, this is Section 38A, Section 38A of the Copyright Act 1957. Section 38A refers to exclusive right of performance. And you see, the provision starts by saying, without prejudice to the rights conferred on authors. Without prejudice to the rights conferred on authors. So Section 38A is very clear in terms of where performers stand if there is a question of priority. If there's a question of priority in terms of importance that authors' rights and performers' rights should be given, authors' rights should be given primary importance. That's very clear from 38A. So no performer rights can be enjoyed such as to be prejudicial to the rights conferred on authors. Another way in which we can understand this is that if there is a work, if there is an original work in which copyright subsists and there is a performance of that work, then quite naturally it is the work which came first and the performance which came second. So naturally, the performance cannot be prejudicial to the author. Again, if you look at Section 14, which tells us the meaning of copyright and provides for the range of copyrights that authors have, you can see under 14A, which talks about the copyright of authors of literary, dramatic, and musical works. This is 14A 3. 14A 3 reads to perform the work in public. So, performance of original works is something which is a copyright. It's a copyright of the author, and performances of works are something which have to be authorized. So, in that sense, we can situate performances to be of secondary importance as compared to works. So now to quickly sort of see where this segment has taken us, we've seen that there are a range, there are different categories of performers, and where these performances are using a specific work, and that work is under copyright protection, then the performance has to be authorized. It has to be authorized. That is the effect of Section 14, read with Section 38A. Now, the fact that we establish that there are a set of people who are deserving of performers' rights, and these performer rights cannot be prejudicial to authors' rights. What exactly are these rights? So, performers enjoy the right under Section 38A, as I was mentioning in the previous slide. Section 38A lists out what are the exclusive rights that are given to performers. And these rights deal with fixation and dealing with that fixated performance. So, over the live performance, the performer has the right of authorizing recording, whether visual or sound recording, And those recordings, the recordings that have been made, the communication of those recordings, that is again something a performer can control. Apart from these economic rights that performers have also been granted moral rights which is under Section 38B. Now, at this point, it is important for me to mention that performer rights in India under the Copyright Act were introduced for the first time in 1994. Though the statute is old, the performers have only been recognized as a category which can be granted intellectual property in their own expression in 1994, and moral rights are of a much later recognition. So 38B was added only in 2012. So there has been an expansion of performers' rights with the 2012 amendment, and primarily this has dealt with performer rights, but also the 2012 amendment brings in an important distinction in economic rights where it talks about the distribution of royalty, wherein performances have been incorporated in cinematograph films. So that is one area which we will be looking at in some detail in the following segments. But just to quickly look at Section 38B, you will see that Section 38B, in terms of its flow, is very similar to the author special rights which are granted to authors, which are the right of attribution and the integrity right. But with respect to performers specifically, you can see the explanation. The explanation reads, for the purposes of this clause, it is hereby clarified that mere removal of any portion of a performance for the purpose of editing or to fit the recording within a limited duration or any other modification required for purely technical reasons shall not be deemed to be prejudicial to the performer's reputation. So this explanation has been inserted because of the industry practice, which is that when a film is made, it is technically important to sometimes minimize the performances that are incorporated in such films. It becomes important. So to ensure that this doesn't lead to unnecessary litigation, this is an explanation which has been specifically inserted within 38B. But apart from that, the tenor of 38B is very similar to author special rights or moral rights that are granted to authors. That is the attribution and the integrity right. Now coming to the second segment. In the second segment, we're going to be taking a look at these two very important questions. Am I a performer? And what exactly am I performing? So consider the first situation. X wishes to record a cover version of a popular song. How is X planning to record this cover version? He has a recording set up at home. The question is X a performer? So obviously this short problem can be made much more substantive in terms that this is not probably just him singing. This could also be him operating certain equipment from which he is generating music to go along with his singing. So it can be made much more substantive, but this is the absolute basic issue, which is that if you are sitting in the comforts of your home and using some device to record yourself singing or using some instrument and attempting to make a cover version of a popular song, are you a performer? So, before we delve deep into this question, I think it's important for those who are attending and who are not very familiar with the meaning of cover version for me to just explain briefly what a cover version is. So, a cover version is a performance of constituent works different from the original performance. So the constituent works of sound recordings that is lyrics and composition, where these are performed by you. These are obviously, this constitutes a distinct performance, different from how the original performer or performers have expressed these constituent works. So it could be Arijit Singh, who was the performer earlier, and now in this situation, it is X. So X is performing these constituent works. But interestingly, in this situation, X has no audience. When X is making this performance, when he is in the process of recording his presentation, his visual or acoustic presentation or both, he has no audience. So um, the fact that in when we were contextualizing our discussion, we were looking to understand performances as those creators who are adding value, who are adding value to consumer perception. So, what value are performers adding when there is no audience? So, there arises a question on whether X can be considered a performer at all. Why? Because there is no audience at this point of time. Now, this is very relevant for a lot of creators who are, in fact, using their homes as part time studios, or who are simply using their laptops to record themselves or phones to record themselves, and who don't have any ready audience in front of them. So, there arises a question of whether they can claim to be performers. To take this up a notch, um, if we consider singers like Mohit Chauhan or dubbing actors like Mona Shetty, they are also getting their performances recorded in a studio. So they also don't seem to be having any audience, so to speak. So uh, if we look at the provision now if we look to understand the interpretation of what a performance is and what a performer is or who a performer is, I'm just going to read this out. Please pay attention. Performance in relation to performer's right means any visual or acoustic presentation made live by one or more performers. This is all that the statute is saying. Nowhere in section 2Q is the statute talking about the need for an audience to be present. It's simply talking about a visual or acoustic presentation, and that's it. And the fact that it must be live. So, for us to now include audiences within this would be to read this provision as against what it literally reads, which is that a performance should be live and it should be a presentation which is visual or acoustic. That's it. And now, if we look to section 2QQ, it gives us an understanding of who a performer is. Now, it says performer includes an actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, person delivering a lecture, or any other person who makes a performance. Here as well, under section 2QQ, we again don't see any specific need for an audience. So, if you are a person who is sitting at your house using your equipment to record yourself singing, then you are a singer. You are a singer, you are a performer, and you are delivering a performance. So, in terms of recognition of this rationale of whether audiences are required in order for a person to be a performer and whether this can be considered as a performance, we look back to the Neha Bhasan case, the Neha Bhasan versus Anand Raj Anand case. It's a 2006 decision of the Delhi High Court. Now, in this decision, it was clearly enunciated that live here only means that the performer is contemporaneously generating an expression. That is it. So there is a visual or acoustic presentation that is made by the person who is looking to perform, a singer, but the requirement of an audience is not there, because the moment you attach audience with this interpretation of performance, then it's going to be very difficult to provide performers' rights to performers who legitimately um, um, who deserve performance rights, like Mohit Chauhan, who is singing in a studio. If you start associating Section 2Q with audiences, he is no longer a performer providing a performance. Is he a singer? Yes. But is he a performer? No. So that is a very disturbing interpretation if in fact we bring it in. In a later reflection, the Delhi High Court in ISRA versus Dharma Productions has in fact considered this question, and they said that this is something which is perhaps a seriously triable issue. But as far as reasoning goes, and as hopefully I've been able to demonstrate, that to link audiences with the interpretation of performance would be quite quite troublesome for performance. So X's cover version, whatever X is looking to do at his place with his own recording equipment and his own expression, this is a performance. And as we've understood, because performances cannot be prejudicial to the rights of authors, if the performer is using constituent works. So if there are lyrics that he's using and there's a composition that he's using, then no matter who you are, no matter if it's X or no matter if you're Y or whoever you are as a creator, you must take permission. If you do not take permission, then you essentially militate against the provisions of the Act. And as I have tried to show, whether you're trying to upload on YouTube or you're trying to upload on TikTok or whichever platform you're looking to upload it at, it doesn't take away the fact that using somebody's work. And I cannot lay enough stress on this. You have to take permissions. Now, coming to the second situation. So, in this situation, X wishes to record herself dancing. She is dancing to a popular song. She gets her friend Y to record her dancing outdoors. Is X a performer? Again, this is something which we often see happening in digital media, especially in reels, wherein performers look to use popular songs and they use it in the background and they dance to it. So here again, the question is X a performer? So if X is a performer, what exactly is X performer? And this is the question on which I look to make a distinction between situation 1 and situation 2. In situation 1, something which we need to understand is that in situation 1, X is using the lyrics. X is using the lyrics and X is using the composition. But what is less clear in situation 2 is what exactly is X using, because X seems to be using the sound recording. It is the sound recording which is used, and obviously within that sound recording there are constituent elements. Those are your lyrics and composition. But nevertheless, the sound recording itself was not being played out. In situation 2, it's a sound recording which is being played. So a common misconception that exists is that X is in fact performing the lyrics. But if you look at it, section 14, and this is the extract which I've taken from section 14. Section 14 talks about your copyrights. And with respect to sound recordings, you can see that Section 14E, and look at clause 3, is very different from how Section 14 is provided for original literary, dramatic, or musical works. So, if I can just take you back to Section 14. Um, yeah. So, if you look at Section 14 and look at 14A3, in 14A3, the statute very clearly makes a distinction between performing the work in public and communicating it to the public. These are two different things. Performance is different, communicating is different. And in section 14E, you can see performance, performing the work in public is not a copyright that sound recording producers have. Sound recording producers have the right to communicate the sound recording to the public. So therefore, in this case, X is no doubt performing, but again, X is not performing the sound recording. X is communicating the sound recording and performing the constituent elements. Okay, this is important to understand. So in the first situation, again, the sound recording is not being played. In the second situation, the sound recording is being played, and that's communicating the sound recording to the public. That's not performing the sound recording to the public. Now, at this juncture, I must also mention that within the industry, there is the usage of this term called public performance. The industry uses this term called public performance. And public performance, from an industry perspective, can mean communication of work to public. Now, this is because of the way in which entities like IPRS and PPL and ISRA, they are interpreting public performance within their articles of association. They explain this to mean communication of work to public. Now, if you look to the history of the copyright statute, you'll be able to see this in much more detail on why exactly the industry has this practice of using a terminology which seems to be starkly different from what is the terminology in the statute itself. So this historical perspective is that performer rights, and as I had mentioned, performer rights were introduced for the first time in 1994. And communication of work to public is a term which is of later addition in the Copyright Act. Earlier, under the Copyright Statute, it was public performance. Public performance was something that meant, in a sense, communication of work to public, what today is communication of work to public. So there has been an evolution of this term called public performance, wherein now performance under the Copyright Act only means performances, and performance under Section 2Q is live, visual, or acoustic presentation. It is distinct from communication of work to public. So, having seen who are performers, what are some categories of performers, what are performers' rights in general, how exactly do we situate performers within the copyright universe, and some examples of whether I can consider myself to be a performer in some situations which are very common, and whether I am actually performing. Let's come to this third segment, which is to look at some digital avenues for performance. So, digital avenues for performers is, in fact, an arena which is the major share of revenue that can essentially come to performers. It forms and can form a much greater share of revenue for performers. Now, this is on account of the pattern in which sound recordings and cinematograph films are distributed. So, sound recordings and cinematograph films, because they are distributed over digital platforms such as OTT platforms, and these OTT platforms are consumed on a large scale, the kind of revenue that OTT platforms are able to generate for such sound recordings or for such cinematograph films means that there's a huge source of revenue from which a percentage can be derived by performance. So OTT platforms are definitely an incredible source of revenue for performers. But because OTT platforms are looking to provide a platform for sound recordings and for cinematograph films, quite clearly, the revenue stream of performers is linked to such sound recording producers and cinematograph film producers. And then you have hosting sites like Instagram or TikTok or YouTube, which are also sites which allow for performers to upload their performances and gain recognition in terms of their performance. But it's important to just keep in mind the situations that we had discussed earlier, that if you are a performer who's looking to upload something on these platforms, you must be wary of what these platforms allow. So the terms and conditions of these platforms, if they're specifically allowing for the use of some sound recording, then it's probably because the that snippet of whatever that's of that snippet of sound recording which is available on that platform is something that's licensed, and that's something that they're allowing you to use. But for you to, for example, take a certain platform and post on a platform and then download it and use it on another platform would probably create more problems. So it's very important to know what exactly that hosting site is, what are the permissions available at that hosting site, and be very, very wary that no matter if you are using somebody's copyrighted work, then Section 38A very clearly says that you cannot have performer rights which are prejudicial to author's rights. You must get authorizations. So, supposing you have these authorizations, supposing your performance is a part of a cinematograph film and it's a part of a sound recording, then one thing is clear, that all these platforms do in fact provide for commercial benefits. They're a means for you to generate income. So, the fact that you're able to draw money from your performances means that uh, this is something which you have a lot of interest in, and something which probably should be regulated. And secondly, um, these performances, because they are made available to such a wide audience, also means that you are gaining a lot of recognition in this process. Now, recognition is something that can come by way of the consumer, obviously, by way of the consumer perceiving your performance on screen. But importantly, in certain cases, if supposing you are a performer like a dubbing actor or a stuntman, then unfortunately, the the performance of such a performer is not something that is recognized for that person. When you watch a film and you see Rani Mukherjee delivering a dialogue, you don't think that it's Mona Shetty. So unless and until the industry specifically recognizes these individuals, unless they take that step and make this a normal course of the practice of the industry, that they should be recognized for their performances, it's going to be very difficult for them to gain that recognition. So segment 3, we looked at some digital avenues for performers. Now coming to segment 4. In segment 4, we're going to be looking at whether performances are original and whether they can take all that discussion from our copyright classes on originality, whether that applies to performances. So you can see this particular shot from this movie Lagan. Now, in Lagan, in this particular image, you can see Amir Khan's character, who's batting. Behind Amir Khan, you can see two layers of uh, performers. You can see one layer who is on the ground itself. These are supporting actors. So for those of you who've seen Lagan, you'll see the rest of the team standing in this first layer. And then you can see on top of these supporting actors, on the hill, are another layer of people who are also shot within this particular shot. So within this one shot, you can see a whole range of people who seem to be delivering some presentation. So it's for the people who are standing on the hill, the level of presentation that's required from them is very, very minimal. The people who are standing in the second layer, there is a higher level of expectation from them. And obviously, the lead protagonist, he is the one who's running the show. There's a lot of expectation from this individual. But from this screen, you can see that in terms of value of what these people are bringing to the cinematograph film, in terms of value addition, perhaps the persons who are on that hill are not providing a kind of value which you need a specific individual to provide. So it could be any one of us wearing a costume and being on that hill, and that would suffice. So the question that we are asking here is whether all performances are capable of being of having sorry for the grammatical error, whether all performances are capable of having performers rights. That's the key question we are asking, because under section 2q, which we had discussed, I'll just take you back to that provision. So under section 2q, we saw performance in relation to performer's right means any visual or acoustic presentation made live by one or more performers. That's all. It doesn't say anything at all. So technically, anybody giving any kind of presentation, no matter how small, would be a performance. So whether it be Amir Khan, whether it be the people on the ground, those supporting actors, or whether it be the people on that hill, they are all satisfying this interpretation. So going by this interpretation, every single presentation is a performance. It wouldn't matter that it's Amir Khan or somebody else. Everybody seems to be delivering a performance. But is that actually the case? So to take this discussion forward, let's look to section 38. Now, section 38 provides for what are performers' rights. So it says performers' rights, where any performer appears or engages in any performance, he shall have a special right to be known as performer's right. This is all. And it is very distinct from how section 13 is phrased. So section 13, which talks about subsistence of copyright, you can see they very specifically require originality for literary, dramatic, musical, and artistic works. That these works must be original in order for copyright to subsist in it. But section 38 talks nothing about originality. So here we have a situation wherein the interpretation of what a performance is doesn't seem to be making any distinction between performances. Everybody seems to be a performer. Whoever is capable of delivering a live presentation, that's a performance. Section 38 also doesn't say anything about performances being original. So what we can then conclude merely on account of reading these provisions is that everybody, whoever presents, acoustic, or whoever makes a live visual acoustic presentation is a performer. But what about the case of extras? Now, this is important because we are now looking at this from the lens of the industry. From the lens of the industry, you will be able to very clearly see a distinction in the way performers are recognized. And this is a given that in the film industry, extras or junior artists are not considered at par with who you consider to be supporting actors or primary actors. So these individuals who are standing on the second tier on the hill, these individuals are who you call extras or junior artists. And as I was trying to explain, the main feature that makes you an extra is that an extra is absolutely replaceable. It wouldn't matter if it was any one of us who was standing on top of those hills. You wouldn't specifically require that presentation at all. It could be anybody wearing a costume with very simple instructions who can carry out this act. So there is no creativity, so to speak. There is some sense of creativity which is required when we consider actors on the field as against the actors on the hill. So, from this image and from our understanding of the industry, something that clearly emerges is that for the industry, every performance is not a performance. This is from the industry perspective. From the industry perspective, there is a segregation which must be made. So, if we make a segregation, on what substantive ground are we going to make that segregation? So the Copyright Act is silent. It doesn't say anything about how we should make this segregation. There was a proviso which was added to Section 2QQ in 2012. I'll be briefly touching on that in the later slides. But as to the interpretation of Section 2Q or Section 2QQ and Section 38, there is no mention of originality. So literally, it doesn't seem to be a substantive standard which we can use to make any distinction. But at the same time, we cannot deny the comparison between copyright and performers' right. Because within copyright, we seem to be very sure about one thing, that not all works are copyrightable. Some works are just works. So a literary work can be a literary work, but for copyright to subsist in it, it has to be original. So what is original is a whole other debate, and because that is covered in so much detail in our classes, I'm sure I'm not getting into the meaning of originality. But for those of us who are attending from the industry, a brief understanding of originality is that as artists, you realize that you bring in some creativity through your skill when you are providing an expression. That creative endeavor, that aesthetic element of your presentation, that is what we call originality. So based on this threshold, we are saying that not all works are copyrightable. Some works are, they have to satisfy this threshold. Similarly, from the industry, we get to understand that not all performances attract performers' right. We must make a segregation. Now let's look at this very interesting insertion that was made by the 2012 amendment to Section 2QQ. So look at this proviso which was added to Section 2QQ. It reads, provided that in a cinematograph film, a person whose performance is casual or incidental in nature and in the normal course of the practice of the industry is not acknowledged anywhere, including in the credits of the film, shall not be treated as a performer. This is a very important insertion that was made through the 2012 amendment. Now, what you will see is that what this proviso is looking to achieve is this. Within the realm of cinematograph films, it is looking to create a segregation on how you will distinguish that a person like a performer, that a person like an extra should not be considered as a performer, and the people on the field should be considered as performers. That is what this provision is looking to achieve. So it's saying that, firstly, that these performances should be casual or incidental, but problematically, it is linking it to the recognition by the industry that these are performances. That's the issue. So, what is casual or incidental is very subjective. Firstly, there is no real explanation of this that is provided within the Copyright Act. Secondly, to allow for the recognition in the industry, and that too normal course of the practice of the industry recognition, to essentially play a big part in recognizing an individual as a performer, can lead to situations wherein entire categories of performers can be excluded from the application of the Copyright Act. So, which is where let me touch on the Beijing Treaty. So, the Beijing Treaty is one of the international intellectual property instruments, which we find, which are found under the aegis of WIPO, the World Intellectual Property Organization. They administer this treaty. Now, the Beijing Treaty is not a treaty which we can see in isolation. We must understand that the Beijing Treaty has evolved upon certain international intellectual property instruments on performer rights which came earlier. So, be it the Rome Convention or be it the WPPT, the WIPO Phonograms and Performances Treaty, these instruments limited the application of performers' rights to phonograms, fixations in phonograms or sound recordings. What the Beijing Treaty looks to accomplish is to extend the right of performers to audiovisual performances. So cinematograph films will come within the domain of the Beijing Treaty. This is what it's looking to achieve. Now, during the course of these negotiations leading up to the Beijing Treaty, India actually played a big part. India was quite active in these negotiations, and we, in fact, provided proposals on what this draft treaty should look like. So, the role of India in these negotiations cannot be undervalued. There was a lot of good contribution that India made. But at the same time, we must understand that India at present is not a party to the Beijing Treaty. That's one. And secondly, the interpretation of who a performer is, as provided by India during these negotiations, is what you see on the screen. They said, performers are actors, singers, musicians, dancers, and other persons who act, sing, deliver, declaim, play in, interpret, or otherwise perform literary or artistic works or expressions of folklore, but does not include performers whose performances are casual or incidental in nature, such as extras. This is what India was proposing at the Beijing Treaty, during the negotiation of Beijing Treaty. And look at what was added in the 2012 Act. Till the point it said casual or incidental in nature, such as extras, it was fine. But in this proviso, they've gone ahead and added an extra line that casual or incidental in nature, they've removed such as extras. So that interpretation, the interpretive value that would have given to the meaning of what is casual or incidental has been removed. And secondly, they've added a very important restriction here, which is the industry will have to recognize you as a performer. This is a seriously problematic insertion. And like I was just pointing out, this is not something India was proposing at the during the negotiations to the Beijing Treaty. So this insertion is in fact very surprising. It's very surprising, and if we look at the parliamentary debates towards the copyright bill 2010, we don't find any such reflection on this proviso being added to the Copyright Act. It has essentially sailed into the act without any deliberation, without any parliamentary deliberation. So one thing seems clear, that this proviso looks to be making a distinction between who can be a performer and who cannot be a performer in cinematograph film. And it is not looking to make this distinction on the point of view of originality. It's looking to make it on the point of view of the industry. So under Section 2QQ proviso, to just recap what I was attempting to bring to your attention, was that recognition of who a performer is in cinematograph film is an industry recognition as per Section 2Q. Now let's come to Section 5. In Section 5, I will be looking at the question of whether performers need empowering. And this is a very important question that I think we must address, because as law students and people who are looking to study performers' rights and performances, we feel sometimes that they require empowerment, they need empowerment, and intellectual property is a sure shot tool to help them achieve solution to their problems. But is that actually the case? So that's something I will look to answer in this segment. Now on your screen, you can see is a popular actor, Sharat Kelkar, and you can also see a shot from Bahubali, where Prabhas played that character. Now, many of you might know, and many of you might not know, that the Hindi voice of Prabhas in Bahubali was Sharat Kelkar. Sharat Kelkar was that voice. So, Sharat Kelkar had very distinctly stated that artists like dubbing artists, like he was the dubbing artist for Prabhas and Bahubali, such artists do not get their due monetarily or otherwise. So, or otherwise here is recognition. So this is an admission by someone who's very senior in the industry, that dubbing artists are not getting paid in terms of what their contribution is, and they are also not getting the right kind of recognition. On your screen is this individual. His name is Javed Gauri. Javed Gauri is a stuntman who has done stunt doubling for actors like Tiger Shroff and other such actors. And there was a 2019 Al Jazeera documentary on stunt artists in India, and he was one of the stuntmen that they had covered. Now, what Javed Gauri is stating here is a story which reflects on stuntmen around the world. So, a lot of stuntmen, in fact, say that film stars get all the credit and remuneration for the work that stuntmen are doing. And in the image that I had showed you earlier of Hrithik Roshan and Mansoor Khan was the one doing the stunts, but here you were crediting Hrithik Roshan for those stunts. So one thing is clear from both of these categories, that there are problems. There definitely are problems. Problems that seem to be something the Copyright Act is targeting. Copyright Act under Section 38A looks to be providing for economic rights, and Section 38B looks to be providing for moral rights. So if in fact there are these provisions under the Copyright Act which can be used for the benefit of performers, why is it not working for them? That's the issue. Quite clearly, these are performers, right? These are performers. Then why isn't it that the copyright is helping them? Copyright Act is helping them. And it's also very clear that these are not extras. These are people who are bringing in a creative element. They are skilled. They're bringing in a creative element. Quite clearly, they seem to be satisfying what in copyright at least we are calling originality. They are satisfying originality. So clearly, they should be capable of enjoying these rights which are being granted. So to answer this question, we must look at how the industry functions. That's very important. So, obviously, I must say this out that during the course of our discussion in this segment and the next, there is an emphasis I'm placing on two categories of performers, on voice actors and stuntmen. I cannot possibly include all categories of these performers. The reason why I'm including these specific categories, these two categories, is because I have done research which involved members of these specific categories of performers, and that's why I can speak from experience of what they have expressed. So one of the things that is very, very, very common in the industry is that the industry is replete. It's flooded with tough contracts, very, very tough contracts. These agreement clauses are phrased in such a way that if a performer were to just read those clauses, he will feel that there is nothing beyond whatever is being offered to him by the producer. This is the nature of the agreement. So, in the agreement, you will find clauses that basically provide for absolute transfer of performers' rights, absolute transfer. And any kind of right that is otherwise available in the Copyright Act, the performer will have to waive it. This is the scope of the agreement. Now, the scope of this agreement and some of these clauses is highly dubious. So, if these clauses were to be challenged, I'm pretty sure that some of these clauses will not stand the test of the scrutiny of the court. But this is a fact. This is a fact that you know producers engage in buyouts. These are contracts which are buyouts. They will buy you out, literally. They will take everything that you have in terms of a right under the Copyright Act. These are tough contracts. Now, another feature of the industry is that while contracts are tough, many of these agreements are not even written. And something that's important, and you will note this, that the mode of assignment, which is under Section 19, and when we read it with Section 30 and 30A, is that agreements under the Copyright Act have to be written. So there are many arrangements which are happening in the industry which are not even put in writing. So they are simply happening on the means of trust, where the performer is trusting the producer. And the second is the power game. And this is something which is very, very central to how the industry functions. And as we understand it, we will note that for a performer to take on the industry would be to essentially take a chance on his livelihood. So his livelihood depends on getting more opportunities in the industry. So unless the performer is really, mentally strong and sure that there is enough industry support for him to keep getting these opportunities, despite the fact that he's going to take on someone like a producer, the chances of these cases happening in court are very, very, very minimal. In fact, there are only a handful of cases you will find where performers have actually taken on producers. So this power game is something which is very, very common in the industry, and for the performer to take on the industry and essentially enforce his rights, it's not an easy task, and this is not something that will just happen. Now, the fact that the industry is replete with tough contracts, and we can't disengage this power imbalance between individual performers and strong parties like producers. How do we balance out this imbalance? Because this seems to be the central issue. If we can balance out this power imbalance, clearly we can be in a better position to get these performer rights enforced. Now, there are two examples I will take to explain my point. One is the movie stunt artists, and the second is the Association of Voice Artists, MSAA and AVA. Now, MSAA represents stuntmen, stunt artists. I keep saying stuntmen. I should not say that. Stunt artists, and stunt directors. It represents them in Bollywood. So, in Bollywood, if a film has to be made in which a stunt has to be taken by the director, then they have to go through the MSAA. There is no way out. So the MSAA will essentially act in favor of the stunt artist member. And then you have an association of voice artists. Now, the Association of Voice Artists is a very different, association in terms of in terms of comparison. So, relatively, while the MSAA has been very, very successful in terms of representing their members, the Association of Voice Artists has not been very effective. So, let's see what the MSAA has been able to achieve. So the MSAA has been able to achieve timely wages and uniformity in wages. So these wage schemes, later, whenever you are reflecting on this discussion, you can look at MSAA's website, Movie Stunt Artists Association's website, right? And you can see that they have clearly published their wage scheme. So if a stunt artist were to provide a stunting presentation over a single shift, there's a certain amount of money. If there is more amount of danger involved, then there is some more amount of money. If it's a foreign shooting, then there is more amount of money that's going to come in. And all of this is going to be managed by the MSAA. So the MSAA seems to be handling this on an incredibly efficient manner. They seem to be doing it really well. So in my research into the effectiveness of the MSAA and these members of the MSAA who are stuntmen, now, I must point out that I had looked to reach out to a lot of stuntmen, but the respondents who actually got back to me were around 19 or 20 of them. And from these respondents, one of the things that seemed very clear was that almost none of them knew about performance rights. Almost none of them. And almost all of them seemed to be satisfied with payments. They were happy with the kind of remuneration they were receiving, and mostly all of them were dissatisfied with the recognition that they were receiving. So this is an eye opener. This is an eye opener in terms of what the NSAA has been able to achieve and what it has not been able to achieve. So the NSAA, as you know, NSAA is not some performer society. NSAA is a simple labor association. It's an association representing its members. And in terms of what it has been able to achieve, it's been able to achieve uniformity of remuneration, and to which the respondents seem fairly happy. Now, in comparison, if you see an association like AVA, now AVA has no set wage system. There is no uniformity. Forget a minimum wage system. There is nothing that they've been able to establish. And this is primarily because while the NSAA has been able to achieve unity among their performers, so there is a community of performers who are looking to work together and who are looking to enforce what are their performers' rights. As far as the AVA is concerned, there is no unity among voice actors, and the dissatisfaction of what I have been able to see across the ranges of interviews that I could conduct within some eminent voice actors in India was that they were uniform about one thing, that neither is remuneration great, neither is the recognition they getting good. So AVA is also a labor association, but you see, the way NSAA has been able to be effective is kudos to them in the way they've been able to structure their wage scheme and maintain that unity among their members. And AVA, because voice actors are essentially individual entities, they exist in small clusters, and there is no real unity. So for the first set of performers, you will see the first set of performers are these stunt artists. They don't need much empowering. So the primary goal that performers' right would look to serve is to give them economic control. So if that's the primary goal, and if the labor association is able to achieve this, they are happy with what they are getting. So the first set of performers don't really need any empowering. And the second set of performers need empowering. They seem to be not getting what is due to them. They don't seem to be getting recognition either. So in the second set of performers, there is an empowering needed. First set of performers, there is not much empowering needed. Now let's focus on this particular existence, the existence of these performers within labor collectives and within the domain of the copywriter. Now, this is something which the WIPO has documented in a lot of detail. So, in terms of performances and the recognition of performances and the remuneration that they're able to derive from the market, this can be done through simply labor collectives, like NSAA is able to do, through simply that. It can be done through a hybrid model, right? So, for instance, in something like the ISRA, the Indian Singers Rights Association, the Indian Singers Rights Association is essentially made as a performer society, but the way they are functioning is to collectively bargain for their rights. So that's sort of like a hybrid model. And then you will have a model in which the performers society doesn't have to depend on any collective bargaining capacity. They are able, and a voice actor will be able to get what is due to that voice actor despite not having any such collective effort. So in terms of application, you can see the performers, categories of performers in India, they are in varying phases, but they have not attained the last phase yet, which is to exist purely as a performer society. That has not happened. We are having performers existing as collectives, as labor collectives, and we are having a hybrid model for some performers, like singers, for example, where they are existing in a hybrid of a labor collective and something of a performer society and under the performers domain. So, according to the WIPO, we can see this transition in any jurisdiction which is looking to apply performance rights. So this is going to be a trend. Initially, there will be focus on performers as somebody who are falling purely within the labor system. There's going to be a transition where they're going to be seen as people who are deserving of IP rights, and there's going to be a hybrid model that's going to come in place. And eventually, this is going to be dealt with purely under IP systems. So that's something which we are yet to see happening in India. So now coming to the final segment, which is how can IP empower performance? So we are basically working on this backdrop. The backdrop is that there seem to be some set of performers who do not need any empowering, or at least they say that they don't need empowering in terms of money's worth. But as we have noticed, that these stuntmen are actually not getting recognized. So there is definitely some empowering that can come through IP. And then there are a set of performers who definitely are not gaining anything from any kind of a labor collective. They definitely need some empowering, and that's going to come through IP. So, how can IP empower these performers? So, the first way in which IP can empower performers is that IP necessitates written agreements. And this is incredibly important. It's one thing for, as a creator, for the person to trust the producer to do what's best in the best interest of the performer. But it's important to understand that in practical considerations, unless and until the agreement is written, there are going to be problems that the performers might face in future. To prove that a certain clause, certain term was agreed, this is going to be a task. So one thing that IP can ensure is that these agreements are going to be written in nature. Second, intellectual property and Copyright Act, and through Copyright Act, performers' rights, it provides for mandatory sharing of royalty. Mandatory sharing of royalty, or otherwise within the purview of Section 18 and Section 19, what we call as the right to receive royalty, or R3. Now, the application of right to receive royalties to performers, this is something which is of some varying discussions. There are two schools of thought here, and I'll give you a brief understanding of why this discussion exists. So the 2012 amendment came into place primarily because of the demand that was being made by lyricists and composers in the music industry and the film industry, who basically wanted a rightful share of revenue from the revenue that was being generated by these producers. So over a period of time, over decades, they found that there was an unfair treatment that was being meted out to their community. And eventually, after Javed Akhtar became a member of parliament, he was able to convince members of the parliament that this was of utmost importance. And eventually, the 2012 amendment, a major chunk of it is actually looking to focus on providing fair treatment to lyricists and composers. So that's the background to right to receive royalties. So the meaning of right to receive royalties in this sense and what was inserted in Section 18 and Section 19 of the Copyright Act was that despite any clause in the agreement to the contrary, which says that you will not be eligible for any royalty, despite that, you are eligible for royalty. So that's mandatory. Any clause which goes against this mandatory scheme will be waived. So, what the 2012 Act also did is that it extended right to receive royalties to performers. So it did this in two senses. One, it revised Section 38A, and what was provided towards the end of Section 38A, that where a performance is incorporated within a cinematograph film, and by nature of agreement where that performance was incorporated, then the cinematograph film producer will enjoy performers' rights. But something that's been added in 2012 is that despite this, the performer must be given royalty. And secondly, the application of Section 39A. Section 39A extends the application of performers' rights with necessary adaptations and modifications to Section 18 and Section 19. So, right to receive royalties were extended to performers within the Copyright Act by the 2012 amendment. Now, this first school of thought, which says that the 2012 amendment was never meant to provide some right to receive royalties to performers. It was intended to be provided to lyricists and composers of sound recordings of cinematograph films. They say that archery cannot be extended to performers. But the fact is that if we look to the industry, the unfair treatment which was complained by lyricists and composers, that unfair treatment and much worse is actually being faced by performers. So the second school of thought, and which to my mind is the more reasonable way to think about application of archery, is that with the inclusion of right to receive royalties, the Indian statute has in fact provided a very progressive development that very important stakeholders in the industry who are performers should be provided with mandatory royalties. This is a very important inclusion that the 2012 Act has created. So if we can recognize if we can recognize ourselves as performers, if we have in fact made some skilled presentation, if we recognize ourselves as performers, then we are also eligible for right to receive royalties, which are mandatory. And third is the recognition of moral rights. So the right of attribution, which is very important, especially if you are looking to be someone who's looking to make a mark in the market without recognition. So money component is definitely something, but money component isn't enough, because just the money component makes you available only to select people who know of your existence. But it's the recognition component which brings you in the eyes of the larger market. So especially in the perspective of some performers, some categories, such as the ones I explained, stuntmen or dubbing actors, who you don't really see on screen or you hear, the only way that they can be recognized is if the industry recognizes them. So as a practice, this is something that the industry in India is starting to develop. It's starting to develop, recognizing stuntmen and dubbing actors, but this is still not a normal course in the practice of the industry. So, like I was telling you, unless and until this becomes a normal course of practice in the industry, the insertion of the proviso to Section 2QQ poses a genuine issue. So, can IP empower performers? It definitely can. Are performers widely aware of the rights that they have under IP? No. So, something that perhaps we are able to achieve through this openly available webinar and something what we are discussing today, and hopefully this reaches as many performers as is possible, is that it's very important to realize that intellectual property is in fact empowering. So, despite the fact that you might be happy with the money component that you're receiving from your labor collective, you must realize that IP can, in fact, empower you in several ways. So, now to look at some of these takeaways. So, the first takeaway is that performances which use copyright work for the purpose of uploading on digital media, you must seek the copyright holder's permission. So if you are an independent artist, if you are somebody who is looking to create something new, you don't really belong to any collective. You're simply sitting at the confines of your house, and you have your own recording equipment. You're recording something. You're taking the help of your friend. If you are using a work for your to help your performance, please take permission. Now, what is the alternate? There is an alternate that's available to not using copyrighted work, which is use a Creative Commons licensed work. So, if you need, say, a soundtrack which runs in the background to something that you're narrating, for example, you can use a website like pixabay.com. What pixabay.com provides are are Creative Commons licensed works. So I'm sure all of you know, at least in as an overview, what Creative Commons is. But to tell you what the effect of Creative Commons licenses is that not every copyright holder is looking to enforce their copyright against you. Some of them are just fine if you attribute them for their work. So even if you were to modify that work, they are okay with it. Even if you were to commercialize that work, they are okay with it. So if you do in fact need something of a in the form of a soundtrack, you can use something which is having a Creative Commons license. That's an alternate. If you are on a platform, if it's a hosting platform which is having original content, then please go through the terms and conditions of that platform. It will clearly demonstrate the uses that you can put those original contents to. And if the hosting site is taking down your video on account of a copyright strike, it's always better to rethink. It's always better to rethink, take out that content and use something which is non-copyrighted. So there is a feeling of comfort sometimes that creators get, which is that they might feel empowered on account of not having received the copyright strike. That despite having used a copyright content, nobody really came after me. Nobody issued a notice and takedown. But um, the chance is that they can. So it is infringing, and there is a chance that they can come after you. So it's always better to rethink and take licenses where they are required. The second takeaway is for those people who are looking to become professionals. If you are a performer who's looking to become a professional. So, as a creator, as we had pointed out, you can call yourself a performer, but being a performer doesn't necessarily mean that you're a professional. So, if you are looking to become a professional performer, seek out your community. It's very important because, in terms of the way in which performer rights is developing, and this is very clear to see from the industry and from how the Copyright Act is also made applicable, is that it's these communities which are looking to derive benefits from the market as labor collectives or as societies, performer societies, and therefore it's important for you to seek out your community. And once you're within that community, and it's important that you once you become a professional, and if you are a professional performer, it's important for you to strengthen your community and look to enforce your performers' rights. This is something which, uh, in the present time, can only be attained collectively. This is something which can happen collectively. Some of us, as performers, are still in the transition stage. We are making that leap from a labor collective to a performer society. Some of us are still within a labor collective. Some of us are not even there. So it's important that if you're looking to become a professional, seek out a community. If you are a professional, strengthen your community and see for sure the benefits that IP can bring to you and performer rights can bring to you. So as references, I'm citing my own research on this area. And these are 3 articles which I published on the area of performer rights. The first article, which is the background performer paradox in India, look to decode why exactly have we inserted something like the proviso to section 2QQ. And that research took me through a lot of negotiations which took place within the Beijing Treaty, and the results I have already discussed with you. For a more detailed reading, please go through this article. In the second article on bewildering predicament of voice actors, I have looked to engage with very senior voice actors within the Indian voice acting industry, and the travails of this industry, it's really difficult to sort of digest as people who are looking to further the scope of IP rights. And the third is the research in which I had focused on the stunt directors, and these 2 studies essentially took me through two different paths. One side told me that they needed something which was empowerment. Another side, they said that we're not really looking for any real empowerment. But nevertheless, at the conclusion, I think I can say that performer rights is incredibly important. And for those of us who might feel that it has no real value, even for them, there is something which performer rights can offer. So with that, I think I will end. So thank you. This is my email ID. Please feel free to write to me if you have any concerns, any queries, any doubts that you have. I'll be happy to take up any questions that you have right now.
Thank you so much, sir, for that wonderful session. And so, are there any questions? You can put it in the live chat, or the guests, participants here can unmute themselves and ask any question if they have any. Sir, I have a question. Can I ask? So my
Uh,
question is related to the point about the contract between performers and producers. So, irrespective of other laws, even if we look at the fact that even under copyright, the arguably moral rights are non-transferable. So, in a situation where the contract allows for such transfer, is it valid? And sir, a related question is that even though the producers agree to provide recognition to the performers, what level of recognition is required? Merely mentioning their names at the end of the movie, is it enough for the performers? So that's my question.
okay. Thank you for that question. And as I had pointed out in my discussion, that these contracts are very tough in the sense that many of these clauses are actually illegal. Some of these clauses are illegal, and if they were challenged in court, there's every chance that these clauses will be struck down. Now, the question that you asked about, say, transfer of moral rights. Now, I'll go one step ahead and tell you that there are contracts in which the producer asks the performer to waive their performer rights, their moral rights. Not just that, there have been situations where the performer has been made to sort of pass off his performance in the name of someone else. In fact, the Neha Bhasin case, the case was entirely centered on Neha Basan's voice being taken by somebody else. There was a person, there was a producer, I think an executive producer of that film. It was a movie with Sohail Khan. So that person had appropriated Neha Basan's singing. So practices in the industry and these written contracts, they are replete with clauses that can definitely be struck down. But on that point, again, I must stress this: the power imbalance in the industry also ensures that the performer never takes this up in court. There are very small, very limited circumstances in which performers have actually been brave enough to go to court. So that's one. What was your second question?
So it was regarding the status of recognition, like what level of recognition is required for performers. Like merely mentioning their name, is it enough, or they have to go beyond that?
The producers.
Yes, sir.
Okay. So you can see in the proviso to section 2QQ, all that the proviso to section 2QQ is saying is, in the normal course of the practice of the industry, they must be given credits. They must be given recognition, including credits. So giving credits is actually enough, because anybody looking to identify who this individual is can see it from the sense of credits. But it is arguable that recognition should go beyond credits, because you see, the film fraternity, in fact, organizes award ceremonies. And you can see for yourself how many of these award ceremonies are actually providing awards to stuntmen. How many of them are actually providing awards to dubbing actors? So, in terms of recognition, we can see that some performers seem to be getting an undue amount of recognition as against those who duly deserve it but are still not getting recognized. So I think recognition is something of the industry's discretion, and that frankly should change. I think, yeah, that should change. But does that answer your question?
Yes, sir, it does. I have a related point to make. So,
Please.
it's clear from the current position of law that the rights that are provided to performers are not enough to protect like them. However, if we look at this problem from the perspective of consumers, so I recently read about reverse passing off. I don't know if it is recognized in India or not. However, if we look at it from that perspective, so consumers are so we portray the work that is done by the performers under the brand or the image, which is the actor. For all the examples that you gave, let's say Ranveer Kapoor, Rani Mukherjee, or Hrithik Roshan. So this is the brand under which we actually try to pass off the work of the performers. So can there be a remedy under this concept of reverse passing off in this situation?
Okay, great question again. Thank you for that. So, in 2006, when the Neha Basan case happened, there were no moral rights. It was only in 2012 that moral rights came in the first place. So, what was as a remedy provided in 2006, at least not expressly stated to be reverse passing off, was a common law remedy. A common law remedy that this person has been deprived of recognition or acknowledgement for their effort. So, in common law, there is that recognition which can exist, and that reverse passing of angle which you're bringing in, if even if not stated expressly, is something which can be considered. But after the coming of moral rights, once moral rights have come into place, now there is no, there is no application of common law to, so to speak, because the Copyright Statutory Copyright Act has essentially overridden common law application. So performers are entitled to moral rights of attribution. They should be attributed. Now, the problem here, as I was mentioning to you, was that
So you're
this
not
is.
audible.
I'm sorry. Am I audible now?
Yeah, now you are.
Okay. So, as a form of recognition, producers must start doing it. This is something which must happen, and performers must take up the mantle to ensure that they are getting recognized. So unless they step up and demand for recognition, this is going to be a slow process for at least some categories of performers.
Thank you so much, sir, for
Yeah,
answering the question. If there are no more questions, I would like to invite Bhavna to give the vote of thanks. On to you, Bhavna.
Am I both audible and visible? Good afternoon, everyone. As we draw this enlightening webinar to a close, I, Bhavna P., student of Christ Academy Institute of Law, Bangalore, and a senior member of CDIPR, take this opportunity to extend a heartfelt vote of thanks to all those who have contributed to making this session a success. First and foremost, I would like to express our deepest gratitude to our esteemed guest speaker, Dr. Rohan Cherian Thomas, for sharing his invaluable knowledge and insights on the topic of performers' rights in the digital age. Your expertise has truly deepened our understanding of the legal framework that governs the creative industries and the challenges faced by performers today. Your detailed presentation on such a complex and evolving topic has indeed been a source of great learning for all of us. I would also like to extend my thanks to all the participants for being such an interactive and engaged audience. A big thank you to the organizing committee and everyone at CDIPR for your hard work behind the scenes in putting this event together. Your dedication, planning, and seamless execution have ensured that this webinar was a resounding success. Once again, thank you to everyone who have been a part of today's session. Have a great day.
thank you.
Thank you, sir.
Thank you so much, sir.
Thank you, sir.